Well, can everyone hear me online?
Yes.
Fabulous. Okay, everyone in the room can hear
Yes.
me. Well, awesome. Well, welcome everyone to the October Knowledge Session on Exemplary Damages and the Environment. This is our first member-led session, which is by Joe Hodson, the paralegal at the shipping firm State Solicitors. My name is Isabel Conroy Ryan, and I'm a representative on the Legal Voices for the Future Committee. I'm an associate in the Climate Risk and Sustainability Group at Minter Ellison, which is an Australian law firm, but I'm based here in the London office. For those that aren't familiar with Legal Voices for the Future, I think we've got a few in the room. This is their first event, so welcome. We are a collaborative knowledge sharing forum that was established by young practitioners from different fields of law, whose objective is to give a voice to a new generation of lawyers. We do this by holding monthly knowledge sessions that are open to all, lawyers and non-lawyers alike. And in order to bring fresh perspective, innovation and determination to pressing global issues such as climate change, each session to date has been organised and led by a different member of the LVF committee, but today marks our very first in a series of member-led sessions. Please refer to our LinkedIn pages for further details about what we do and how you can get involved, including how to submit a proposal for your own member-led session. Our next session will be on the 9th of November on the topic of decarbonisation in shipping. Tickets are available through Eventbrite, and we really hope that you can join us. Tonight's session, though, is a very exciting one. It's going to be in 3 parts. The first will be Joe's presentation of exemplary damages and the environment. Part 2 will be an interview with expert Maribel Rodriguez, who is the co-founder of Conservation Mitigation and Law and Wildlife. I would like to note that Professor Dr. Gert Van Caster, unfortunately, is a late apology due to a deposition in the US, which he was assisting on as an expert, and the time zone very tricky. So that will be part 2, and the final part is the most interactive part of our session, and that's going to be a creative content, which is particularly fun, and we encourage all that are online and also here in the room with us to stay. For those online, you'll be actually broken into a breakout room, and you'll discuss with a volunteer facilitator the creative content, and then small groups will be formed here in the room. Please note that we have got this session recorded, and they are made available online to our YouTube page for those that can't attend. At the conclusion of this evening, which we anticipate to be between 8:30 and 9 o'clock, we'll be heading to the Nearby Bar, All Bar 1, to discuss what we've learned here tonight, and also to continue networking. And hopefully, if you're online next time, you can join us in person. I'd like to give particular thanks to the University of Law for hosting us, and to our volunteer facilitators who are here giving us their time. But without further ado, I would love to welcome our presenter, Joe. And if you could please join me in tonight's session.
Thank you all for being here. It's a pleasure and a privilege to have this opportunity to discuss exemplary damages and environmental applications with you. There's no particularly unique reason why environmentalism matters to me. I think it just plainly ought to matter to everyone. It will matter ever more palpably more people for the foreseeable future. There is, however, a specific reason why I'm thinking about exemplary damages. I stumbled across this topic at university when I undertook a research project for my master's degree on the Court of Appeals ruling in Actors versus Financial Claims Solutions Limited, and I somehow found that project to be a much more fun and fascinating exercise than anything shrouded in such drab words as Financial Claims Solutions Limited had any right to be. So my hope is that my enthusiasm will assist somewhat in bringing this topic to life for you. But more important than mere fun is the fact that deterrence is surely the holy grail of environmentalism. Insofar as it's possible to disincentivize environmental destruction, so that it actually happens less, that's the perfect outcome. I'm going to start by introducing the exemplary damages and the controversy of the appropriateness of this remedy before going into how it works in England and Wales and elsewhere, and then examine its application to environmental claims. Um, so exemplary damages, also known as punitive damages, they are a civil remedy awarded in addition to the more usual remedy of compensatory damages, with the aim of punishing or deterring the defendant's conduct. Compensatory damages, on the other hand, merely attempt to put the claimant back in the position they originally would have been in, but for the defendant's action as far as can be done by money. The core criticism of exemplary damages by those who oppose their views is that punishment and deterrence should instead be considered the sole preserve of criminal law, because the objectives of punishment and deterrence warrant a higher level of protection for the defendant, which criminal procedure provides. For example, in England and Wales, if you are charged with a crime, your opponent has to satisfy the beyond reasonable doubt standard of proof, whereas if they are instead bringing a civil lawsuit, they would only need to win on the balance of probability. In most English civil cases, they would not face the additional hurdle of having to convince a jury.
Okay, this had a little bit of sound on the invitation and it just like the hour, and if I would just a little bit more into the hour. Is that better online?
I think it's quite big.
A little bit. I think it's just the hour.
Oh right, okay. I'm not sure how
this will work.
I've never seen it used before. Okay.
Yeah, better. Thank you.
Yes,
Okay.
yes, much better now. Thank you so much.
Okay.
Thank you.
Yeah. Opposition to exemplary damages also comes from a somewhat understandable reluctance to allow claimants to win through litigation more money than they had originally lost. Concerns that they may be too unpredictable, and a fear that such a possibility may encourage unmeritorious claims. Most civil law jurisdictions do not provide this remedy in any circumstances, and often refuse on public policy grounds to enforce parts of foreign judgments containing an award of exemplary damages. The Hague Choice of Court Convention 2006 and the Hague Judgment Convention 2019 both specifically provide that it is permissible to refuse foreign awards of exemplary damages. And even in common law jurisdictions where exemplary damages are available in certain circumstances, judges have sometimes treated this remedy with so much suspicion that they have on occasion established some conspicuously unprincipled and tortuously reasoned precedents to restrict the availability of exemplary damages. For a particularly egregious example of this, before it was overturned, the case of AB v Southwest Water limited their availability exclusively to causes of action where they had been awarded before the cut-off date of leading case of Rich versus Barnard in 1964, as opposed to articulating some substantial factor that might make a given cause of action inappropriate for the remedy. However, the core argument in favour of exemplary damages is that they are practically useful. The notion that civil, as opposed to criminal wrongs, do not need to be deterred evinces an overconfidence in the criminal law to recognise every crime it needs to and to produce the correct result reliably despite its higher standard of proof. There are inevitably gaps in the law where a seriously harmful wrong will not be caught by the criminal law, and where compensation will not deter recidivism or even fully remedy the harm done. Furthermore, the bite of compensation is not equally felt by all defendants. The same amount of compensation for a given loss might financially ruin poor defendants, yet go almost unnoticed by a rich defendant. By ensuring that a given civil wrong cannot be committed with effective impunity, exemplary damages can also reduce this clearly unjust disparity, as the courts typically take the defendant's financial needs into account when assessing the appropriate level of exemplary damages in a given case. These arguments in favour of exemplary damages being further forced in the environmental context, because environmental destruction is typically carried out by entities who are wealthy enough to price in their compensation, and some environmentally destructive legal roles which merit deterrence, such as environmental instances of private nuisance and assault and violence of stature, is only a civil wrong rather than crime. Story of exemplary damages in the common law world begins in the 1763 case of Wilkes versus Wood. The controversial journalist John Wilkes, who the commercial litigators among us may recognize as the statue outside the Rolls building, brought an action in trespass in respect of a search of his premises under an unlawful warrant by the state. Wilkes successfully claimed exemplary damages, having argued that striking damages would not put a stop to those unlawful proceedings. For the next 200 years, the boundaries of this remedy are somewhat unclear. The current rule, which clarifies the limits of exemplary damages in England and Wales, comes from the 1964 House of Lords case of Rooks versus Barnard. This is also a case which briefly established that a threat to withdraw one's labour could be actionable in default of intimidation, so that part of the case was swiftly detailed by Parliament. This is the only that it is only the precedent in relation to damages that remains authoritative. In this judgment, Lord Devlin opined that exemplary damages were an undesirable anomaly, but he considered that he lacked the authority to abolish them. So instead, he restricted their availability to 3 categories based on the kind of circumstances where they had previously been awarded. The first category is oppressive, arbitrary, or unconstitutional conduct committed by public officials. I learned from a recent tweet by Sue Dent that this category is more or less encapsulated by the 19th century word bougerie, in case that helps anyone remember it. The second category is where a tortfeasor cynically disregards the claimant's rights, having calculated that what they stand to gain from their conduct will outweigh what they lose through paying compensation. Alas, I don't know a whimsical old word for this category, but I suspect that it's probably a good one. The third category is any instance where legislation expressly states that exemplary damages should be available. In this judgment, Lord Devlin also reclassified damages awarded in respect of mental distress as being essentially a further form of compensation rather than exemplary damages. These damages are referred to as aggravated damages. Further case law has clarified that the calculation required to meet the criteria for the second category does not necessarily have to be an accurate or rigorous piece of arithmetic. And indeed, as AXA, the Financial Claims Solutions recently showed, the threshold is met even if the defendant's anticipated profit completely fails to materialize. It similarly does not matter if the profit sought by the defendant consists of something other than money. However, the calculation does have to be a conscious exercise directly related to the fraud. Mere continuation of an otherwise legitimate business, for example, an anticipated continuation of usual profits by a newspaper which publishes a defamatory statement, does not suffice. Exemplary damages are not available for breaches of contract in English law. As there, the doctrine of efficient breach applies instead. It's considered more acceptable for a contractual party to decide that paying compensation is more convenient than performing their contractual obligations than it would be for a different kind of civil wrongdoing. It is important to note that within the Rooks category, the judge, or in some causes of action, the jury, still has discretion to decide whether it is appropriate in all circumstances to award exemplary damages, and if so, by how much. If parallel criminal proceedings are being brought against the same defendant in respect of the same conduct, the court will not assume that these obviate the need for deterrence, although on the facts of a given case, they may well do so. When the Law Commission made their recommendation on reforming exemplary damages in 1997, they noted a large consensus among their consultees that the post-Brooks position of English law on exemplary damages is unsatisfactory. Some wanted to see exemplary damages abolished entirely, while others wanted them to be more widely available. Their ultimate recommendation, which has not been adopted by Parliament, is that the three categories in Brooks should be replaced by a simpler and more clearly justifiable rule that exemplary damages should be available wherever the defendant's conduct shows deliberate and outrageous disregard of the claimant's rights, and adequate recourse is not available through the criminal law. This dissatisfaction with Brooks has been simmering away for some time. Many other common law jurisdictions chose not to follow that precedent at all. And even in England, the Court of Appeal in Broom v. Catherine attempted to revolt against higher precedent by claiming that Barnard had been decided per in curiam. In that case, Lord Denning drew attention to the inconsistency whereby the first category punishes public officials more harshly than private entities for causing the same harm, and the second category punishes greed more harshly than malice and recklessness for causing the same harm. The House of Lords sternly overruled him for overstepping his authority, but a fair point had been made. The Emperor was certainly shabbily dressed, if not entirely unclothed. A good and principled test for exemplary damages should, in my view, be focused on the factors that genuinely affect the justice of the outcome, the harm done to the claimant, and the wealth and cynicism of the defendant. In the rest of the common law world, exemplary damages are usually more widely available than in England and Wales, due to the widespread refusal to follow Rip versus Barnard. And some jurisdictions have also departed from the English exclusion of contractual features in the cause of action where exemplary damages are available. There are some common law jurisdictions which have instead gone in the direction of abolishing exemplary damages, including a small minority of US states. There is much that can also be critiqued about the decisions that those jurisdictions have made, not least the trend that in American jurisprudence, whereby various courts and legislatures have imposed maximum caps on exemplary damages rules, with the result that the wealthiest corporations are not effectively forced to internalize the cost of their wrongdoing. The most infamous case of this was an environmental one, where the Supreme Court reduced Exxon Shipping's exemplary liability for the Exxon Valdez oil spill from 2.5 billion to 500 million. Exemplary damages incurred much undeserved bad press in America from the deceptively mundane sounding hot coffee case, in which McDonald's served coffee at such unusually high temperatures that it caused the claimant third-degree burns when spilled. McDonald's were required to pay exemplary damages, but when stripped of the full context of the harm these damages were of the harm, these damages were easily mocked in the media as an excessive remedy for a seemingly frivolous claim. This selective and sensationalist reporting has somewhat skewed public perception. In terms of international law, while I've already noted that the Hague Conference Conventions have gone out of their way to ensure that exemplary damages may be refused transnational enforcement, it is also worth noting that the Convention on Limitation of Liability for Maritime Claims goes to some extent in the opposite direction. This convention enables ship owners to limit the amount of compensation they pay for various maritime claims, including pollution claims, but this limit does not apply where the defendant acted intentionally or recklessly. And this is precisely the category for which exemplary damages are most likely to be applicable. Arguably, this exception for exemplary, intentional and reckless harm acknowledges the legitimacy of deterrence in civil law. To my mind, it is clear that exemplary damages have enormous potential to deter environmental destruction, though that potential is often not fully realised for various reasons. Relying on compensatory damages alone is certainly going to be inadequate when the defendants are wealthy enough to be able to price in compensation, and this in itself makes exemplary damages a crucial tool in the environmentalist argument. They feature already in the current surge of American climate litigation, for example, the claim recently filed by California against various oil companies, and they were also successfully claimed in the litigation concerning toxic chemicals brought by US lawyer Robert Bennett, who was recently portrayed doing so by Mark Ruffalo in the film Dark Water. The Rooks category clearly narrows the scope for environmental claims to seek exemplary damages in England and Wales. But all three of the categories can be potentially helpful. The first category is commonly relied on in actions against the police, and it is now more important than ever to ensure that the police are deterred from overstepping their ever-loosening limits against environmental protests. More broadly, any abuse of state power which amounts to a civil wrong is in theory fair game. The second category is probably the one with most environmental potential because of the huge role of the profit motive in driving us towards environmental catastrophe. Whether in the case of greenhouse gases, PFAS, sewage dumping, or overfishing, wealthy corporations have repeatedly chosen to harm the environment with the knowledge of the harm they are doing on the basis that it is financially worthwhile. The second category should therefore help to deprive them of this impunity. Some of the most egregiously cynical cases of greenwashing will fall into this category too, and the profit motive certainly applies there. For example, exemplary damages have been sought in the Dieselgate litigation concerning manufacturers fitting cars with devices that misled regulatory inspectors as to their rate of emissions. However, there may otherwise be difficulty in establishing sufficient deliberateness for exemplary damages in greenwashing cases, as greenwashing is often simply the result of insufficient ecological literacy, and it's important to not cross the line into deterring businesses from seeking to bolster their green credentials at all. The third category of express statutory provisions provides further ammunition for environmentalists quite directly. The Environment Act 2021 provides that exemplary damages can be awarded as the court sees fit when a landowner breaches a conservation covenant with a government designated responsible body. What this means, at least on paper, is that these bodies will be equipped to robustly enforce quasi-contractual local land charges aimed at conserving the environment and or resources on given piece of land, notwithstanding the usual English rule that prohibits exemplary damages for breach of contract. However, the effectiveness of this mechanism depends heavily on the willingness of both landowners and responsible bodies to sign up for and enforce such agreements, and on their belief that it's in their best interest to do so. It is hard to say with confidence that they will have such motivation in abundant supply, and it must be borne in mind that the threat of exemplary damages may work just as well to deter the formation of conservation covenants as to ensure that they are upheld. It will be fascinating to see how this new innovation functions in practice. While the only recipient of the damages in a given case will be the claimant, it is possible for the court to take into account the impact of the defendant's actions on wider society when exercising their discretion to decide whether to award exemplary damages and if so, how much. For example, in Axe versus Financial Gain Solutions, the defendants have defrauded an insurer, and the Court of Appeal took into account the fact that the risk of insurance fraud drives up premiums, which unfairly punishes buyers, and the court cited this harm to demonstrate the outrageousness of the defendant's conduct. Given that environmental harms come back to bite pretty much all of us in one way or another, this legitimization of considering harm to persons other than the claimant in the assessment of damages is clearly a welcome approach. However, exemplary damages are not a panacea that can solve all our ecological worries, and it is important to acknowledge their limitations. We have already looked at how the imposition of caps on exemplary damages causes them to fall short of deterring wrongdoing by those who can afford it, and the fact that some jurisdictions will refuse to enforce them. Their ability to deter wrongdoing by the wealthiest will often also be stymied by the corporate veil, by the fact that some of the most vulnerable claimants will be unable to afford the necessary litigation in the first place, or by the fact that environmentally destructive conduct is not always unlawful in the first place. Last week, we saw in Wimbledon Dyson that the post-Brexit return of foreign non-convenience is likely to substantially thin out the number of claims against multinationals that can successfully be brought in England too. On top of all this, polluters have formidable political and financial capital, which they can relentlessly do deploy to push the dial in their favour. Even when exemplary damages work as well as can be expected, the destruction of course may simply be beyond the ability of any amount of money to put right. They're not reliably a path to salvation, and indeed the same can be said of the law itself. Much else is also needed. They can really help. Thank you. I'm now going to go through our interview. Is there anything I need to do at my end here? I can see Maribel there.
Hello.
Just checking, was the sound in the end better for everyone online?
Yeah.
I think so. I think what we might do is, I'm sorry that you've got me in front of this, but that looks right. How it comes. And then, just to make sure it's as nice as possible for the room. Yeah.
Can you see Maribel? I've pinned her to the screen.
Yeah, you might. Yeah, but this one's so slow, everybody. No, we might go through again. There we go.
I can see.
I think Maribel has frozen.
Okay. I think you're breaking up a little bit, Janetta, but I think there we go. Can you?
But you can see me, not Maribel, because I think Maribel actually dropped out of the call now. She started kind of cutting off sound, so I would expect her to join any minute. So,
excellent. Well, in the meantime, while we wait for Maribel to rejoin, does anyone have any questions for the summary?
Yeah, actually, I'll be happy to take any more later. Okay.
I learned a new word, so I'm feeling pretty impressed. But I was wanted to ask, what's your in the course of your research and when you're working, where do you think if there's an exemplary damages case in environmental law, do you think there's a particular area? Would it be shipping or would it be pollution? What do you think?
I mean, I don't think there's any particular reason to expect to cover one person more than another. Like within the category where it's available. Yeah, I mean, I guess that I mean, due to the case we had last week, there's going to be probably less of the transnational claims, so it'll probably be more something based on English law, I would guess. But that's just you know, we'd be keen.
Definitely. No, it's a tricky one because I think it's sort of the thing from Australia where kind of going down a different path with a lot of the litigation routes.
Yeah.
And it's really interesting to see what people are doing overseas as well. And obviously, in the common law jurisdiction, we look to the UK a lot. Sometimes, and then sometimes we don't. We look the other way very, very, very quickly. But yeah, I think it's very interesting and really great presentation. There's a lot of stuff in there that I didn't know. I think it's a new frontier with environmental claims, and it sounds like exemplary damages are a good one. You know, so my boss is Sarah Barker, and she's on the World Economic Forum Climate Change Committee, and she was saying, you know, the world good that there are so many potential claims, and I think exemplary damages, everyone understands what damages are. I think we don't have to be aware, and I think it's still fear in a lot of people, but I think your point about tax is an interesting one.
I mean, the hope is that, I guess, these would be something that litigators use for in-house counsel, is that it will be able to be in a position to say to, you know, their bosses, well, actually, no, we can't do that, because, you know, it doesn't add up, because if you think it does, then the court's going to punish you anyway.
And do you think it's reputational? That's another risk that a lot of companies aren't thinking of. They try and price it in.
Well, I mean, in theory, because back in Wolf, they referred to this idea that the jury, because that was a jury case. Part of the function of damages was to mark the jury's disapproval of the conduct. So yeah, I guess in that sense, there is a kind of moralistic component to it that it could harm reputation.
Oh,
Yes, please.
Good on you.
I think you put it out.
yeah.
You mentioned that because we got to be but I guess I was thinking, I was thinking question that how much do you think is going to be like can go up to in that
Well, in America, they have put caps on exemplary damages. So the Supreme Court case I was talking about with the Exxon Valdez oil spill, the Supreme Court said that in federal maritime cases, exemplary damages are capped at 1-to-1 with compensatory damages, which is why it fell so dramatically. I don't think that in England or Wales that is a thing at this point. I hope it doesn't become a thing. but who knows? But yeah, that kind of logic has been used by opponents of exemplary damages. You know, surely we can't have this many times more than compensation. But that ignores whether or not it's actually an effective deterrent. And you had a question as well.
Yeah, I'm aware of any companies being caught out pricing in damages as part of over.
Ooh,
Because that I think would be the real risk for a lot of companies today. So if you've got pricing coming in, that means people are going to struggle within that.
I do remember when I was there was one of the cases on Bailey that they were talking about someone being cross-examined on the kind of calculation that had taken place and whether or not it was sufficiently cynical or not to qualify as that. So yeah, I mean, I guess those things will come out, which is really interesting.
That is a great question. This is wonderful. We have Maribel back in a minute. Just before we get to our interview section, we've got Aruna here, who is our Robert Case Professor at the University of Law. We just wanted to say a quick word.
Yeah, so I just wanted to welcome you to the University of Law in Moorgate. So my name is Aruna Verma and I'm the Chief of Students. So it's amazing that you reached out to us and really grateful for having you here. Be really safe and enjoy. But I just want to come to her. So Joe, I'm sorry I missed this, but I kind of got the tail end of the question, so it sounded really interesting. So thank you, and I'll let you carry on.
Thank you
Great.
so much.
Thank you. Thanks very much.
I think we've got through, we're getting through the hour, Aruna, and I think now we are ready I think there she is. Hello, Maribel. How's your connection?
I feel Maribel has frozen for me, at least here.
Just here, hopefully for long.
Let me just message her on chat asking her to switch off her video because I think it's just too much for her internet.
That might be true. And what we might do in the interim, if there's still issues in a minute or two, we might switch my 1, 2, 3 session parts, and we might go to creative content in the intro. Would that work?
I mean, I don't mind, I guess,
But just mindful of Maribel's time.
yeah, exactly.
So like,
I think, Isabel, I think that's a good idea because Maribel has been messaging me saying her internet keeps cutting off. So it's either that we give her time to restart or reset her home settings. So I'll take it, well, offline to my phone with her, and you guys enjoy the creative discussion in the meantime.
I'm gonna have so much creative discussion right now. I'm really excited. What do you got? Well, no. Oh, look at this. Okay, we're gonna have really creative time now. So, not on the wall. Hey, well, we'd love to really just roll with the punches. So what was the best way forward with the creative content? Was it that the video?
Oh, I think Maribel is back on a phone, right, Maribel?
Yes. I don't know what's happening. I'm sorry. It never happened to me.
Oh my
before.
God, that's okay. You know, one of those days. It
Yeah.
has to
Okay,
be. And off you go.
welcome, Maribel. It's good to have you here at last.
Thank you.
Please, like I think we've had a bit of it in intro, but please tell us a bit about yourself and your work.
Thank you, Joe. Thank you for the kind invitation, and my apologies for this. I hope I can stay at least the time of the interview. So I must say I'm a bit nervous because I'm secretly hoping that I can inspire some of you today. And this is because in the conservation world where I work, we are in need of lawyers who believe that their work can have an impact in tackling some of the environmental problems that we have nowadays, but also lawyers who dare to think out of the box. And I think this is why I'm loving so much the session today and also your presentation, Joe. I love the idea of exemplary damages. So I suppose when I started studying environmental law, I also had this idea of wanting to make an impact with my work. And I've worked as a legal researcher for many years, and there's been this increasing frustration that my work was not meaningful enough. So I decided to, because of this vital need to do something that matters, I started working with organizations, with conservation organizations on the ground, and help them solve their legal issues, but also try to bring alternative legal solutions to the problems that they're trying to tackle. And this is, one example of this is my work in conservation litigation. Conservation litigation is born out of the need to provide an alternative legal solution to illegal wildlife trade. So when we started looking into this, the other co-founder of conservation litigation, Jacob Phelps, and myself, we were looking at what was happening in the illegal wildlife trade world. And we saw that the use of law was insufficient. We were using criminal law, but there were not enough criminal prosecutions, and the punishments, when they happened, they were not enough. But most importantly, what we saw is that the criminal prosecutions were not tackling the impact that illegal wildlife trade has in biodiversity law. Now, we are hearing nowadays very often, science is telling us that we are in a biodiversity crisis. And so we thought, what can we do to improve the situation? And this is when we decided to ask offenders to pay for actions needed to restore biodiversity to the place where it was before this happened. And so nowadays we work with in many countries with local organizations on the ground, trying to help them implement this idea.
Thank you. I'm curious as to the insights that you gleaned from your experience into the differing approaches to remedy. So which remedy frameworks do you find offer the most hope for environmental justice?
So, so we started looking into the different frameworks for remedies in the illegal wildlife trade world, but I think this is also useful for other sectors. And what we saw is that there was this single approach of trying to look for damages or compensation using as a basis the valuation of the harm in 3 different ways for biodiversity. The first way is using the market value of species, of individuals. So, for instance, one orangutan in the wild is worth, I think, 35,000 pounds. The second way was default value. So in some countries, you have laws that determine the value of critical endangered species. And so if you wanted to request damages, you would just have to go to the law and look for the price. In Georgia, for instance, brown bears that are critically endangered are worth 15,000 pounds. And then the third way is valuation of ecosystem services. You would take one individual and understand what are the services that provide to the ecosystem. So for instance, orangutans are seed dispersers. So you would attach a value to that service and then you would make the calculations. This last way is really burdensome and complicated. So what we saw is that these 3 ways do not really consider the whole range of harms. You have the harm to the individual, what happens to the harm that you cause to the species, to the ecosystem, and also harm to society, to cultural, religious values. But especially what we saw is that this type of remediation is not covering, in fact, remediation actions. So, for instance, I'm thinking now if you have an orangutan in the wild, an orangutan illegally traded, this compensation is not covering for the care and rehabilitation of the animal. So this is when we thought we need to work more towards remediation rather than compensation. Yeah, I think this. I hope this is a good explanation.
I'm curious about the concept of restorative damages, which is the context in which I first learned about it actually. So please tell us about that.
So yes, so what we're doing in other cases is that we are focusing on, let's say, instead of valuing the harm, we're trying to value the remedies. And obviously this is different in every case. So I'm going to give you an example. In our first case, we worked with an Indonesian NGO, a local NGO. And we started civil proceeding against an illegal zoo that was holding an orangutan illegally. This is why you will hear the orangutan example very often. And so we looked into the different types of harm that they were in this case. And then we requested the remedies. So in the case of the orangutan, the individual, we requested remedies to restore the harm that was caused to the individual. How? By requesting the costs of care and rehabilitation and reintroduction in the wild for the animal. This is clear. But there was also harm to the species at large, because when you take one individual out of a critically endangered population, you're harming the whole population. So, and we didn't want to make it very complicated for remedies. This ecosystem valuation was too much for us, too burdensome. So we thought, let's make it simple. If you take one out of the wild, you have to put one back in the wild. And how to do so? We thought, let's create the environment to allow a certain population of orangutans to grow in one individual. And how to do so? Let's ask the offender to pay for extra monitoring, extra patrolling of this population for a number of years, 7, which is the time that an infant orangutan takes to become an adult. And then the last type of harm that we focused on was harm to society, cultural harm. Orangutans in Indonesia are really an iconic, in the world, they're iconic species. They are in cartoons, they are in books, in photographs. People come from all over the world to visit orangutans. So we thought, let's find remedies to restore this harm. And we thought of public apologies to the people of Indonesia, but also public awareness. We asked the offender to pay for an education campaign to show the harms of illegal wildlife trade, but also a board next to where the animal is now, explaining why the animal there and why that's wrong. Now, as you can imagine, the bill starts zooming up very quickly. And what we believe is that this is not only useful for illegal wildlife trade as driver of biodiversity loss, but very soon we're going to have to start trying this with deforestation companies, illegal mining, agriculture, and other sectors.
Which jurisdictions or fora do you consider to be most inclined towards this?
So at the beginning, we thought we would hardly find anyone, any jurisdiction. But as we started doing legal analysis, we found that this is possible in most of the jurisdictions we looked into. So I have a list here of countries. We looked into Indonesia, this was possible. Thailand, possible. Liberia, possible. Cameroon, Georgia, Brazil, Angola, Mexico, Philippines, Uganda, China. I think in a way, this is possible in most of them. China is a very good jurisdiction and it has very good remedial actions in the last 2-3 years. But quite remarkably, there was one jurisdiction that it was very unclear. Cameroon doesn't have exactly the most clear laws in the world. But still, we've seen that NGOs and the state have succeeded in requesting compensation for ecological harm in cases of illegal wildlife trade. And I think this shows how important it is not only to have the laws, but also to have the correct enforcement and to have knowledgeable judges that can apply these laws.
Thank you. From a strategic litigation perspective, to what extent should the generosity of remedies available usually be weighed against other factors in deciding where to bring it up?
I'd say, Joe, the remedies are starting point, but for strategic reasons, we have to consider many other things. We have, especially in our jurisdictions, in the jurisdictions where we work, we consider who can be the plaintiff, who can be the defendant, what are the procedural constraints, do we need to use civil, criminal, or administrative jurisdictions in some instances, of how expensive it is, what happens if we lose, but also more, let's say, more practical risks like the physical and personal risks of the plaintiffs, risks of retaliation, slap suits, and how possible is it going to be to implement the remedies in the country. So I'd say remedies are just the starting point, but there are many other things that we need to consider for it to be strategic.
In your view, to effectively deter a wealthy corporation from causing further environmental damage, how hard does an award of damages need to hit?
Yeah, I think, we haven't looked yet into exemplary damages, but from the remedies point of view, when you do a list of remedies completely, it quickly comes to a very high number. So let me give you an example again of a live chimpanzee. If we try to list the actions that are needed to restore the harm to a chimpanzee, we have to consider for the care and the rehabilitation of the animal, that it's going to be around 20,000 GBP. But chimpanzees cannot be put back in the wild. They have to be in captivity for over 50 years, which is more or less what experts consider is their life span. So very quickly, you're already in the £1 million. But when you take one chimpanzee out of the wild, you're not only taking one chimpanzee. Normally in trade, there are baby chimpanzees. And when you take a baby chimpanzee, it's because you have killed the mother. So now there you have 2 chimpanzees. On top of that, you have to add the other costs of patrolling and monitoring. So very quickly it comes to a very high number that can be very deterrent. But still, Joe, my personal opinion, and maybe Zaneta, who's an expert in climate litigation, can agree with me. I think it is when you have a strategic litigation in a good number and wide enough, this is enough deterrent for corporations. And this is what happened on climate change. You have a lot of litigation around the world, and you already see that corporations are really worried about their sustainability policies, their environmental and the climate risks. So I think it's a bit of both.
Right. Thanks for that. To what extent do you think that the introduction of new crimes, such as ecocide, can, will, or should take over the role currently played by civil remedies in environmental law?
Joe, I think all alternative legal pathways that we can have, be it ecocide or rights of nature or remedies, I think they all are trying to achieve the same goal. And therefore, I consider that they shouldn't be mutually exclusive. They should be used in combination. Now, for rights of nature and for ecocides, they still have to find their way in legal systems. The advantage with remedies is that they are already there. So we can start already testing those in courts. By the time ecocides and rights of nature are in legal systems, then we can start combining both, all the alternatives. I think we have to use them all of them. United we stand. So let's try to use them both, all of them.
Although, of course, if we do it at the same time, then there's likely to be a lot of double jeopardy arguments as to, well, for example, in England, very often, if there are parallel criminal proceedings in the same matter, then that could potentially undermine the appropriateness of exemplary damages. So, I mean, I don't know how widespread that is elsewhere. Sorry, can you hear me?
No, could you? Sorry, I'm very sorry. Could you speak closer to the mic?
Right. Oh, right. Okay. So I was talking about I was talking about double jeopardy because you're talking about bringing both civil and criminal remedies at the same time. I may have misunderstood if you weren't talking about bringing it in the same matter. But bringing both in the same matter could be quite challenging. These double jeopardy arguments, but yeah. Yeah, so most of the people in attendance this evening are early career legal professionals or law students who want to pursue work that contributes to the protection of the environment. What piece of advice would you give to them in this position?
Joe, I think it took me so long to find my way that I'm not sure I'm the right one to give any advice. But what I would say to my young self is I think it's important for us for them to give themselves the time to grow, to learn, to study, not either a master or study. Well, in internet now we have many possibilities and we have many seminars, but also find the person that inspired you and talk to them and try to work with them, learn from them. Like you have to unlock your full potential. Also find your way. What is the best thing you do? Are you a better lawyer, litigator, a researcher, a prosecutor, a judge? I think that's also very important where you can contribute more. But I think for me, the most important thing is to stick to your goals, to stick to your motivation, and be brave and be solid in what you do.
Thank you. Now I'm going to open it to the floor. Do we have any other questions from Maribel?
And online as well, if anyone
Yes.
has questions they want to raise their hand.
She did mention about Jeanette's opinion a few questions back. I don't know if Jeanette had anything to say about it.
I don't want like opinions, it's not my session, but I have a question for Maribel so that we benefit from her expertise, which is, Maribel, I wonder, I'm always fascinated when you talk about the value of an orangutan as such. And you know that in my work, I look at ecosystems, and I just wonder whether you could share with me and with the audience, how would you apply that logic that you have just presented us with in terms of orangutan, a baby orangutan, its mother, to an ecosystem? If we were, okay, what is the ecosystem function of this orangutan and how it can be compensated? And whether, maybe the follow-up is, would specific performance or mandatory injunction under English law be the vehicle that you would ask the court to grant in such case?
Sanita, I think for the orangutan case, the Indonesian lawyers discussed this very much. And the problem with trying to make such calculations is that it's almost impossible. It's really expensive, complicated, and judges don't have the knowledge to understand. So in our limited capacity and in our limited sector, which is illegal wildlife trade, we try to make it simple by making this comparison. So I think we try to avoid complicated calculations, but I expect in the future we come to habitats and we can think of something innovative. But for the moment, I'm afraid I don't have a proper answer.
What I hear you say, though, it's like it would be almost counterproductive to do that, to try to calculate the value of an orangutan to the ecosystem, because you would like get to a court and just argue about percentage, like 10 or 5%, right? Like you don't want as lawyers to start getting bogged down on details, which we love to do, right? You want the restorative relief to be granted. So it seems that it's better to look at what it costs to restore rather than how much value the orangutan had. That's what I heard you say. I'm not sure that I'm putting too much in your mouth.
Yeah. Thanks for translating this, Anita. Also because there's, especially in these countries, there's more to the economic value of a species. There are places in the island of Borneo where orangutans are gods. Same happens with tigers, same happens with elephants. So you cannot put a price on your god. So this is why we like to concentrate in values, but also, yeah, it's a complicated calculation, and it's very expensive as well. And for us, access to justice is also very important. Now we work with plaintiffs who are ministries, but the moment you want to have an NGO as a plaintiff, an NGO doesn't have the capacity to pay for such valuations, and they are not possible for all animals.
Thank you.
So injunction, you also asked about injunctions, right?
So I was just thinking, I know you did the research in a lot of Asian countries, but thinking to the UK, for example, should there be an extraterritorial case if you want the plaintiff to do something, actively remedy? I think years since law school, right? But specific for performance would be contractual remedy, whereas mandatory injunction would also cover torts. Is that true? And under mandatory injunction, you could potentially argue with the judge that damages are not adequate, we need restoration, and mandatory injunction just gives you that kind of means or terms of what to and how to restore. Am I getting that right? Completely wrong?
Listen, we haven't worked very much with mandatory injunctions. Also because we haven't worked that much in common law countries. So our focus is remedies when the harm is done. And so we try to stay a bit away from, depending on the jurisdiction, but we try to stay away from damages as well. But I suppose it depends on the jurisdiction. There probably are jurisdictions where injunctions are useful in that sense.
Thank you.
And do you ever come across any difficulties from the local population or any witness, I don't know,
And I think we're just going to repeat the question. Do you mind repeating the question into Al?
We don't have to read it because we have the
So I would perhaps, because we can't hear that question, so if Joe could repeat it so that Maribel can hear it, or if you have like a running mic, that could help as well.
She's literally just come up there, so I think
Hi, thank you so much for that. Okay, great. Now, I just had a question about who your typical defendant is in this kind of case. And do they vary between one jurisdiction and the other? And also if you ever encounter hostility in the local population and in potential witnesses that you might be trying to get to testify in your cases.
Thank you. So you're asking me about the type of defendants, right? So in our cases, we're starting and we're just testing this in courts. So obviously we don't want, let's say, the poor defendants that don't have any capacity to pay. Also because it's really not fair in illegal wildlife trade. There's a lot of poor people that do the hunting, and then what you want to look at is into the middle, let's say, side of the chain. But we also don't want to be too greedy in the sense that we think that we're not ready to bring in the big masterminds and kingpins to court, because they are the ones who have the fancy lawyers and the big pockets. So for the moment, we're trying to go into this mid side of the chain and bring in. So in Indonesia, we have this illegal zoo. In other countries, we have corrupt governors and also corporations and people who are selling the wildlife rather than hunting it. And then, sorry, the other question I couldn't hear.
I think it was hostility from do you face like hostility from the local populations and potential witnesses that you're do you find that that there is hostility among the local populations or potential witnesses that you're trying to bring to your side?
You mean local population, if we are using them as witnesses? Is this the question?
Well, generally or specifically as witnesses.
Yeah. So, well, we have, now I'm going to think about the cases we have. So in the cases we have, all the witnesses are local, right? And so far, there is no case where we find that the specific illegal trade has harmed the local population. However, if we think that the animals that we're dealing with have a particular value for a particular population, indigenous population or local population, in that case, we certainly would contact them and ask them to participate. But the goal is restore nature. We're not, let's say, we're not trying to, if necessary, we would bring local populations, but they're not our targeted plaintiff, let's say, if I can put it this way.
Have
Another question. Do you want to come to this?
So I'm sorry. It's
not your fault.
Not your fault at all.
Hi, thank you. I was just wondering, kind of from a practical perspective, two things. So, how do you kind of decide what cases you take on, and also, how do you get your cases funded? And do you use kind of local lawyers on the ground, or do they do it pro bono? Or do you pay them? So that's kind of sounds like a rude question, but just wondering.
Thank you. So, well, the case, we work with local NGOs. So we explain what we do, and together with them, mostly them, they are the ones that select the cases, taking into consideration all these factors that I mentioned. We need to see what type of remedies, but we also need to see who will be the plaintiff, who will be the defendant, what are the procedural constraints, how are we going to execute the remedy, implement the remedies in the field. But because one of the things that happened, we're working now in cases in Cameroon, Liberia, Indonesia, and India. And one of the things we need to take into consideration is what is most effective, or how can we do this most effectively? And I think in all countries, except for Indonesia, in all the other 3 countries, it is most effective to do it together with the criminal prosecution. So we have to make sure that our local organizations have a good case management system and they are very solid in their evidence. And then about the funding, for the moment, we have a DEFRA grant, an Illegal Wildlife Trade Challenge grant. And so this is funding our next 4 cases. In another case in Italy, we're working with DLA Piper. They are providing legal advice and representation of the NGO pro bono. But certainly, I think for all biodiversity litigation, funding is very scarce. And I think funders do not just grasp the idea of biodiversity litigation. So this is something that we are really struggling with.
Then, whether here or online. I guess we can move on to the content. Thank you so much, Maribel, for joining us. Some really interesting cases.
Thank you so much. Thank you so much, Joe, and the whole team for your patience also. Thank you.
Thank you. Yeah.
Thank you.
And what we'll do is we'll share, there's obviously links to Maribel's organisation online, and honestly, Maribel is absolutely amazing. Thank you so much for all the technical work you did. And now what we're going to do is, for those that haven't had an opportunity to read the article, we've actually got the video as well of the okay. You're going to think I can't work computers, which might be true. Now, here we go. So this is the William Shatner. Yeah, very good. And that's rain, and I'm just setting it around here. Oh, thank God for that. Here we go.
After hitching a ride aboard Blue Or.
But Joe might give an intro in the meantime.
During the show of hands, yeah, have people read the article otherwise? Yeah. Because if people in the read the article, then it may not be necessary. But I got a general knowledge there, so
Let me check. It's working now, so yeah, on the spot. It might not be. Anyway, this is good. Yeah, but how did everyone get a chance or not really? We got a lot of nods. No, would people prefer to watch the video, or should we break into groups? Show of hands. Shall we?
Yeah, well, let's put it to the vote.
What we might do a few. Yeah, what do you think?
I think it's best if we watch the video.
Shall we watch a video? Yeah, let's do it.
It's 9-minute video.
Yeah, we'll watch it. Yeah, and they can't hear me. Okay.
Yeah.
Okay. what we might share sounds.
What he said when he came back down that made me want to invite him on the show. Listen to this.
What you have given me is the most profound experience I can imagine. I'm so filled with emotion about what just happened. It's extraordinary, extraordinary. This is life and that's death. And it's in an instant, you go, wow, that's death. That's what I saw.
That's amazing. That's amazing.
Wow. I am overwhelmed.
All these years as an actor, and maybe his most powerful moment on screen came when he wasn't acting at all. William Shatner joins us on Primetime. Congratulations, and it's good to have you.
Thank you. I watch you all the time. You're a wonderful, wonderful commentator. And it's a joy to hear you, and I'm so glad to be on your program. You know, perforce you need to talk about the dark things that are happening, the dramatic things that can affect us all. Here I am, adding to your darkness. I wish I could bring a message of lightness to leaven the terrible news you keep announcing, because it is terrible news, the way the country is being torn asunder. And there's another, even more important fact that that moved me to tears, is when I saw the bright blue covering of Earth that's only 50 miles wide, and we plunged through it at 2,500 miles an hour, broke through it, and then all of a sudden, like a punch in the face, there was the blackness of space, and none of the mystery of the twinkling stars, the galaxies, just pure blackness, because the sun was in my face and the window and whatever the reasons were. Space is cold and ominous and ugly, and it really threatens death. There's death there. And you look down, and there's this warm, nurturing planet. We've all heard it's cliche now, vulnerable and fragile and all that kind of thing. But it's even more than that. That's death up there and life down here. And between the two, ruining this planet as we are, we're on the verge to bring you the good news that we're at the tipping point. We haven't got time to wait 30 years and argue about a few $1 billion, which we should, how much should we invest in global warming? We're there. And so all these terrible things happening in the body politic is merely a hesitation before we all, I mean, it's just terrible. And I wish I had better news and more entertainment and jokes to tell you. But I was moved to tears by what I saw, and I come back filled with, overwhelmed by sadness and empathy for this beautiful thing we call Earth.
But I think that there is a promise in the truth of that for you, which I think, you know, it lets people know what really matters. And that once you're up above it all, literally. And it, you know, one of the members of my team found something that is so cool to me, because it's from Star Trek. And it's something that you were saying as a line as an actor. And I want to ask you what the line means to you now that you've actually lived it. I'll play it for everybody. You'll remember the scene when you see it.
You know the greatest danger facing us is ourselves, an irrational fear of the unknown. But there's no such thing as the unknown. Only things temporarily hidden, temporarily not understood. All decks, stand by. Captain out.
We are the enemy. There is no unknown, only what is not understood in the moment. What does that line mean to you now?
Well, you know, all these things are true and they're not true. The cliches are not cliches. What is true is this. It is the human tendency, no matter whether it's your personal life, your business life, your love life. If it's not going well, it's better. You know, I won't talk. I won't come home, or I'll be quiet, or I won't say anything. It's so much easier. Burying your head in the sand another instant about global warming and the destruction of the planet is suicide for all of us. And you know, I'm not ready to go, but I've experienced the Earth a lot longer than most people. What is tragic is if our children, especially our children's children, don't have a chance to be part of this beautiful thing we call Earth, and it's just sad. So it doesn't leaven the terrible things that are happening in Washington and the stupidity of the human beings who put themselves first and not mankind, let alone their country. It is irrational.
Are you surprised by how impacted you were?
Flabbergasted. I was sobbing, and I couldn't control it because I was overwhelmed. It was like a death in a life. I couldn't control it for several minutes afterwards. And although I've been speaking about it today because everybody's interested, it apparently went went
Viral.
it hit the news, all viral all over the world. I wrote a song in my album that I've got up now called Bill, which is So Far From the Moon, when I was at my depth of a loss and everything, and Armstrong had just walked on the moon, and I was literally and figuratively so far from the moon. Brad Paisley accompanies me on it, and the irony of me going closer to the moon and having this kind of success is ironic because things are falling apart, and and that's why I was overwhelmed. I wanted to. I didn't think consciously of bringing back the message, but I was wondering why am I crying? What is overwhelmed me with emotion to the point that I could hardly speak. I'm an actor. I should have been able to control it. I was unable to. It was like hearing the death of someone you love, and suddenly the world no longer exists, but this blinding emotional moment.
Well, look, I wouldn't shy away from it because I think the authenticity of it is what is so impressive to so many. You mentioned the song in the new album. You mind if I play a little bit of it?
No, please.
Here you go.
I think we're good. And on that note, I'm going to pass back to Joe to kind of introduce the creative content.
Yeah. So do you have our facilitators here, like ready around the room?
Yeah.
Okay. Okay. So I guess if you start the breakout groups whenever.
Yeah, and the facilitators will lead you.
Yeah. So just like turn around your chairs, talk to the nearest people. One of them, in theory, should be a facilitator. Yeah. Yeah.
And then Janetta's going to be on breakout room duty for those online. Thank you, everybody. And we'll see when we come back out of these little groups to discuss. Okay. You're back? Okay. So, we might start perhaps in the room with each of our wonderful facilitators, whoever's access to sharing a few reflections they've had on the questions and the video and the article. So,
If they can come forward as well to the owl so that we can also hear them.
and I think if you can stand a little bit away from it, it's sort of yeah, close, but yeah. I love the owl.
Okay, so we got this one. So our group discussed the question about how we can rise above the part of ourselves that goes towards self-destruction in this planet. And we just discussed about the theologic theory about probably like one of our member studies theology, and she has like a paper on this, and there is a theory that as human beings we also have a predisposition after like original sin that we are predisposed to actually destroy ourselves when someone kind of and so we all come together and express our belief that we have really to engage for like in this change of patterns, because also some development or some technology or some modernization of our culture and our society now become very handy and convenient, and sometimes we have to properly like make an effort to see, okay, this is going in the wrong direction, and it must be like a cultural shift in government and policies, especially also in corporations, they need to change the way they're looking at things, and not just getting like profit and constant growth, and also trying to understand that also our time on Earth is just really but there's like really we don't really have a purpose. Okay. Sorry, it's my thing. So basically we don't have to stress too much about like constant growth because sometimes it's more about how like we live community, how we live like our life, and it's, as you said, like cultural shift is gonna take constant growth, just as we see destroying ourselves. And we just touched upon the greater filter theory, and how like going out in space and looking and finding other life or organism of things. This can lead to desperation, or it can lead to maybe we made it to the greater filter, or the greater filter is ahead of us, and we're asking the question. Oh, yeah, that's right. Amazing. Yes, so our group answered primarily question 1, which says that basically what should progress look like. So I touched upon what you were talking about. You know, we shouldn't necessarily always be thinking about progression in one way in terms of developing new technologies and things like that. A lot of time we can focus on observing what we already do have. And also kind of rephrasing what progress is. And then we spoke about colonizing space. What we thought about that. Whether there's anyone else wants to bring in a more point to yeah, perfect. Exactly with the idea of and forward. Well, the narrative so well. For those online that might not have been able to quite catch that, is a really good point about how this group talked about degrowth and this concept of BDP, and I'm absolutely butchering what was a wonderfully eloquent response, but hopefully, yeah. Great, it sounds like it's very, very interesting, and I'm interested you've got colonization of space. That's pretty, and you all do that in about 10 minutes, so I'm pretty impressed by it. We might now click our online group if they're doing.
Yeah, so we had 2 groups, all very small but very intimate, which is always good for conversation. I would, Svetlana, if you're still here, maybe you could summarize our conversation, and then Sarah or Mingzi theirs, if that's okay. And I think, Svetlana, would you like to start?
You want me to start?
Yes, please.
Sorry, everyone, for my name being plastered over the screen yet again. I feel like it's been stuck there, even though it shouldn't have, but anyhow. So Zanetta and I had a really lovely chat, and I hope that I do it justice. But I think we kind of focused on the idea of Shatner being effectively extrapolating himself from, the planet and going into what he explains is like this ultimate blackness that he has never experienced before. And then that experience giving him kind of the insight of realizing what's happening to the planet that he had just left. So it's almost as if it took him, he had to leave the planet in order to realize how fragile the ecosystems that he's a part of actually are. And I don't know if it's fair to say, Zanetta, but I think we focused on that idea and then went into details about it. But I don't want to monopolize the chat, so I'm going to leave it to the other group.
Yeah, I think that was excellent. Sarah, I saw you unmute yourself. Do you want to tell us what you and Mingzi talked about?
Sure. It's just to clarify, it's just for the first question, right?
Honestly, anywhere the discussion takes you. We have the questions just to like navigate people, but usually you just go on your own because everybody has their unique contribution. So honestly, anywhere it took you.
We talked a little bit about degrowth and living, human progress being about living within the boundaries of what we have available to the earth, and that's really important, living within the kind of donut economics, the resources that we have, and that small is beautiful, and we're already so hyper connected. Pulling away and forming like new communities isn't necessarily going to be the worst thing. and that our inability to kind of think in that way just kind of is linked to a lack of imagination and potentially like a lack of thinking about thinking in generative and regenerative ways. So it's the actual creative energy that's lacking, and we don't really have that vision for the future, and we haven't really created one where that exists, and that we're not constantly seeking outward, but we're looking more for solutions inward. That kind of took us on a lot of different roads, but I'll wait for the conversation to get there, and then we can pop back in if there's time.
Thank you.
Nothing else I might put up in
Yeah. I think we should probably put the chairs down.
And I just want to thank everybody for being so lovely and pleasant. And we hope you had a great time. Everyone in the room, we're just going to give this back. Everyone online, thank you so much. We'll hopefully see you on the 9th for the next event, which is at HSF on decarbonisation and shipping. And hope you have a great Wednesday evening. And if you're at home, hopefully you can get a glass of something you love. See you soon.
Thank you, everybody. Bye.
Everybody. Bye.
Thanks, everyone.
That's important.